Katrina wants to know, she's in appeal. In an appeal, if we want to call a witness, do we need to do a send 7 and a send 30? Send 7 to show change of setting preference following a pop, and would like the head to discuss how this setting can meet my child's needs. Then the send 30 to call the SENCO head of the school name to show they can't meet needs. Oh, I guess Katrina is already in appeal. If you are past your case review form date, then yes, you will need to do a send 7 to change the witnesses. You will need to do a POP form, which is a placement form. It's confirmation of placement. It confirms that your preferred school can offer a place and can meet needs in writing. It can be a witness statement. It doesn't have to be that form. It can be a witness statement. Often settings write a witness statement instead. If the head of your preferred school is in agreement to coming as a witness, you don't need, you just do a send 7 and name them as a witness and ask them nicely. They say yes, and they come. You need to do nothing else other than make sure that they've submitted a witness statement. If you want a SENCO or a head to come who is refusing to come, that is when you need to ask tribunal to order them to come. And there's a process that you need to go through. It's not the first step. You don't ask tribunal to order them straight away. There's a process you need to go through. You need to have a paper trail of requesting their attendance and then refusing. It's also worth talking to the local authority. If it's a local authority's named school, if the local authority is naming the school, they will almost certainly bring the head teacher or SENCO as their witness. You don't both need them as a witness. Witness is a bit of a confrontational term. They're not witnessing for the local authority and against you. They're there as an expert witness, right? Not for or against anyone or anything. They're to help the judge understand the intricacies of your child's case from their professional viewpoint. So if the local authority are bringing the head of the school that you don't want, you don't need to bring them as well. You will still get to question them. The judge will get to question them.
That's when it's useful if we're looking at witnesses for if you've had an independent assessment done, educational psychology, occupational therapy. If you have had that, you can call those people as your witness and they will be defending their report. They will be there individually to you because the local authority EP will ask them questions, the judge will ask them questions. You can, but they will be independent of that, but they will be witnessing their evidence that they have seen personally for your child. So that's when we're talking about evidence and a witness, if you're bringing your own, they will state exactly what they have seen and what their professional opinion is on your child's needs. So that's what they're witnessing. They're not saying, oh, we're going to side with you. I mean, essentially they will be stating exactly, and you'll only be calling your own professional if you believe that they are absolutely going to be giving information that is beneficial to you. But it's not a criminal situation, not a criminal court case. We're not looking at somebody sort of going against you and sort of arguing in that respect.